Hello and welcome to the 31st lecture of this lecture series on international arbitration practice. This lecture is a part of chapter 2 on invoking arbitration in international commercial arbitrations and international investment arbitrations. In this lecture, we will deal with the 7th part of the 12-part checklist on ICSID jurisdiction. To provide context to this lecture, it would do well to quote Article 25(1) of the ICSID Convention, which states, "The jurisdiction of the Centre shall extend to any legal dispute arising directly out of an investment between a contracting state or any constituent, subdivision or agency of a contracting state designated to the Centre by that state and a national of another contracting state, which the parties to the dispute consent in writing to submit to the Centre. When the parties have given their consent, no party may withdraw its consent unilaterally." We can derive the ingredients of this provision, which are legal dispute. Legal dispute directly arises out of an investment. Legal dispute is between a contracting state and a national of another contracting state. Parties to the dispute provide written consent to ICSID jurisdiction. Now, we'll see how each of these items figures out in the notice invoking arbitration. We have taken the Discovery LLC vs Slovakia dispute. Now let's compare that with the checklist. Item 51 of the checklist on existence of legal dispute is reflected in the notice. A. Claimant in Slovakia have a legal dispute. The matters at issue are legal disputes within the meaning of Article 25(1) of the ICSID Convention, as they concern Slovakia's violations of the claimant's rights under the VIII and international law. Note that this is quite brief because Part 3 of the notice, titled Statement of Facts, describes in detail the facts leading to the dispute. Part 4, titled Claims, deals with how the host state's actions have violated the VIII. And Part 5, that is Arbitration under the VIII, pertain to satisfaction of conditions for invoking arbitration, where these aspects have been extensively dealt with. Item 52 is dispute emanates out of claimant's investment. The notice says, B. The dispute arises directly out of claimant's investment. The claimant held directly or indirectly an investment in the territory of the Slovak Republic within the meaning of the ICSID Convention as well as within the meaning of the VIII. While the term investment is not defined in the Convention, the development of ICSID case law indicates that there are three main criteria used to determine the existence of an investment under the ICSID Convention. 1. Contribution. 2. Risk and 3. Duration. The claimant's investment clearly satisfied these criteria, being an investment concerning the exploration and development of natural resources in the respondent's territory over the course of at least a decade, and in which the claimant invested significant sums but has seen no return. The notice states that since the ICSID Convention does not define investment, case law suggests the criteria for investment which is satisfied by the claimant. Now, item 53 of the checklist is host state is a party to the ICSID, and in the notice it figures out like this. C. Slovakia is a contracting state to the ICSID Convention. As stated in para 93 above, Slovakia became a party to the convention on 27 September 1993 with an effective date of 26 June 1994. Therefore, Slovakia is and remains a contracting state to the convention. Item 54 is the claimant is a national of another contracting party to the ICSID. In the Discovery LLC notice, it states, D. The claimant is a national of another contracting state. The claimant is a national of another contracting state as defined by Article 25(2)(b) of the Convention as detailed in para 87 and 88 above. Recollect that Article 25(1) of the ICSID Convention specifies these requirements. The phrase national of another contracting state is defined in Article 25(2)(b) of the Convention in the context of juridical persons in the following way. 2. National of another contracting state means B. Any juridical person which had the nationality of a contracting state other than the state party to the dispute on the date on which the parties consented to submit such dispute to conciliation or arbitration, and any juridical person which had the nationality of the contracting state party to the dispute on that date and which, because of foreign control, the parties have agreed should be treated as a national of another contracting state for the purposes of this convention. Note that the ingredients for satisfying the nationality requirement for a juridical person were already addressed under item 16 of the checklist, which read: if the claimant, the juridical person, is a national of host state party to the arbitration on the date of consent, information and documents demonstrating agreement of parties to treat the juridical person as a national of another contracting party to the ICSID, which is found in Article 25 2b of the ICSID Convention, read with Rule 22d2 of the ICSID Institution Rules. Item 55 of the checklist is that both parties have consented to ICSID jurisdiction. The requirement of consent was already addressed in items 15, 16, 18 and 21 of the checklist, and therefore under item 55 there is a mere mention to consent to ICSID jurisdiction with cross-referencing to the relevant paragraphs. The arbitration notice in discovery versus Slovakia states: E. The claimant and Slovakia have both consented to ICSID jurisdiction. Finally, both the claimant and Slovakia have expressed their consent in writing to ICSID jurisdiction as stated in paragraphs 95 to 96 above. Item 56 of the checklist relates to date of signature of VIT or MIT, its date of entry into force and other evidence of consent by host state, which is reflected in Rule 22b2 of the ICSID Institution Rules. Note that this is already dealt with in terms of item 44. Host state is a party to the ICSID Convention, and item 45, that is the details of the VIT. So that's all in this lecture. Bye bye and stay safe.